Play action. And Manning's going to heave one. There's a flag. Beckham on a one-handed catch. How in the world?
Welcome back, my good friends. What you just saw was Odell Beckham Jr. with this awesome one-handed catch. I am so happy to say that I taught him everything he knows about catching a football. Let's watch it one more time. There it is. Thank you for making me proud. No, I'm just kidding. I did not teach him everything he knows about catching footballs. I better say that was a joke before I get sued for defamation, right? Okay. So Odell Beckham Jr., one heck of a great football player. He's played on the Giants, the Browns, and he went to the Super Bowl with the Rams. And he signed a very, very big multi-year contract with Nike, making tons of money. And now it has led to a very big lawsuit. So what a sweetheart. In addition to him making a lot of money, now there's a lot of lawyers making a lot of money from his contract, okay? So what we're going to do is go over that contract and this $20 million lawsuit he has over Nike. And as I always say, the way I like to teach law is kind of these interesting cases, these funny cases, and kind of like explain then, when constitutional issues come up, breach of contract issues come up, and kind of like civil procedure issues, all right? So it's going to be a heck of a great episode, as always, I hope, right? And in this lawsuit, so Odell Beckham Jr. filed his lawsuit against Nike in the state of Oregon. Now, how do you pronounce it? Is it Oregon or Oregon? I'm pretty sure it's Oregon, but, let's see. If any Oregoners, are out there, you can tell me if I'm pronouncing Oregon wrong. All right, so he sues them in Oregon. And in the state court, not the federal court. Now, as I've always said in many, many other episodes, right? The first order of business is jurisdiction. Okay? I've said it before, and it is extremely important in every case, and especially in this one. Why the heck did he sue Nike in Oregon? In the year 2014, when he signed the contract with Nike, there was a provision in that contract that said the two parties agree, Nike and Odell Beckham Jr. agree that if there's any lawsuits between us in the future, it has to be handled in Oregon. All right. Now, why did Nike insist upon that? It's very simple. And that's because Nike is located in Oregon. Wow, what a coincidence that Nike is located there. They're located in Portland and nearby, that's their headquarters in Portland, Oregon. And it's and it insists that the lawsuits are handled there, okay? And clearly, look, here's a few statistics here. There's something like 8,000 Nike employees in and around Portland. And the state of Oregon just loves Nike, right? Who they don't love is Joe Samo, okay? It's not, or Odell Beckham probably, So it's an important issue. And those contract provisions are almost always enforced by the courts, meaning the courts will hold the parties to that. So for Odell Beckham, he has to go to Nike country, and he would have to win this lawsuit in front of a judge who, potentially loves Nike, in front of jurors that love Nike. Do you see what I'm saying? So it's going to be a little tough on him, and that is in every contract there should be or there is it's called a dispute resolution clause. And all of you watching this, you have signed probably 100 contracts, and every contract that you've signed has this provision in it, some sort of dispute resolution provision, okay? And I'm going to give you a few examples. Always that little to proceed, click here, right? Most people just click here, and then what you have agreed to is this contract. And then if you ever want to read those terms and provisions, all right, there's a there will almost always be what's called a dispute resolution clause. And for example, let's say you buy shoes or products from Nike.com, okay? What I did is I pulled the terms and services from Nike.com, and it's really simple. Here's the website. Right? So I found it, but, instead of pulling all that on the website, you could go to Nike.com, you scroll all the way to the bottom, in very small print, it'll say terms of sale or terms of service. All right. So let's say you have a dispute with Nike. It says here, this is from the contract, choice of law, jurisdiction, time limits for claims. You agree that these terms and any dispute between you and Nike shall be governed in all respects by Oregon law, without regard to choice of law provisions and not by the 1980 United Convention on Contracts for International Sale. So that even if there's some laws that if you buy the shoes and you live in France or something, so then there's these United Nations kind of like default rules, but you can contract out of them. So Nike says, we're not agreeing to those default rules. We're agreeing to Oregon law, except where provided by applicable law without limitation to any statutory rights for consumers. You agree that all disputes, claims, and legal proceedings directly or indirectly arising out of or relating to Nike stores, including but not limited to the purchase of Nike products, shall be resolved individually without resort to any class action and exclusively in the state or federal courts located in Oregon, okay, or Multnomah County, Oregon. All right, that's where Portland is. Now, we have a lot to unwrap there, okay, because there's a lot of rights that you have kind of given up, when you buy a Nike product here. And it's not, I don't want to single out Nike. All companies do this, right? So what it says here, and there's always this except we're prohibited by law, because maybe there's some sort of law in some state or something that says, even if this contract provision is in here, it's not enforceable. That's very rare. In fact, it's so rare that I think it doesn't exist. I can't even think of any state that has a law like that, okay? So what it says here is if you have a dispute against Nike, like I said, you have to go to Oregon. Now, I know a lot of you are thinking, it's like, come on, Samo, what, we're going to go to Oregon because we're disputing $100 shoe sale? Exactly. Nobody would do that, right? But more importantly, than $100 shoe sale is also, let's say somebody, purchase whatever it is, clothes or shoes or something, and it leads to some sort of weird injury, right? And there's some sort of personal injury dispute or something. You would still, and not just with Nike, with all companies, you would have to go to the state they're in, and you have to sue them in that state, okay? Regardless if you live in Florida or New York or Hawaii, you have to go to that state. So it's a very big issue here, and it doesn't even relate to the substance of the issue, like whether or not the shoes cause that injury. Someone's wearing some sort of shoes and then it develops some sort of injury or something. We're not even discussing whether or not that's a good claim. We're just discussing where the proper jurisdiction is. Okay, and then Nike does something else here that most companies do. It says here also that you will be shall be resolved individually without resort to any form of class action. What the heck is Nike talking about here? Is that, so let's say Nike, whatever, they promise that some sort of shoes are, no animal products, like no leather and no this, no that. So there's a particular shoe, it's a vegan shoe or whatever, right? And then it turns out later, oh, wow, there was a little bit of animal products that went in there. So everyone that bought these shoes, they should get a refund. Or a partial refund because the advertising was misleading, right? I mean, that's very misleading to have animal products in something they say is no animal products, right? It would be like saying this Run It By My Lawyer podcast is just awesome, right? No, that is true though. Okay, so in that dispute, so everyone bought these shoes for, $80, right? So what they're saying is that you can't have one law firm that just does one class action for everyone so that everyone gets their $80 back. You're agreeing that you'll never join any sort of class action like that. The reason why it's there is because Nike then knows that nobody, there are not going to be a lot of people that go to Oregon just to file a lawsuit for $80. Now, it would be worth it for one law firm to do it for like 100,000 people, right? Because it's one lawsuit. That's a class action. One lawsuit for 100,000 people, $80, 100,000, what is that? $8 million lawsuit, right? So it would be worth it for one law firm to do that. But what wouldn't be worth it would be to file individual lawsuits over this freaking $80. So that's why in that dispute resolution clause, in addition to forcing you to go to Oregon to file a lawsuit, they also say that you can't join a class action. And then the next one, let's see, you consent to waive all defenses of lack of personal jurisdiction and inconvenient form. So even if it's more convenient to have the lawsuit in, some other state, you're waiving all of that because you were agreeing to go to Oregon. All right. Now, and then the next provision in there, all claims shall be brought within 1 year after the claim arises. Okay. So, whoa, what does that mean? Or like in California, if there's some sort of negligence lawsuit, you have 2 years to file it from when you discovered the negligence. So what they're agreeing to here, what they're having you agree to is, I'll agree to file the lawsuit within 1 year. So they're shortening the statute of limitations in their contract, right? Now what I did is just so you know, for the heck of it, right? A lot of people buy on Amazon.com, right? So I said, let me go to Amazon.com's terms and services and their contracts. So here we go. Here we have Amazon. Okay, disputes. Any dispute or claim relating in any use of Amazon service will be adjudicated in the state or federal courts in King County, Washington, and you consent to exclusive jurisdiction and venue in these courts. We each waive any right to a jury trial. Okay, so what is Amazon.com doing there? Amazon is saying that, why do they want you to go to King County, Washington? And that's because guess where Amazon is located, right? King County, Washington. Okay, so obviously there's tens of thousands of employees in Amazon. They probably, contribute who knows how many millions of dollars to that county, right? And chances are everyone in that county, or most of them, really like Amazon. So if you have someone like Joe Samo trying to go after Amazon in Amazon country, that's funny, Amazon country, not the one in South America, the other Amazon country in Washington state. Okay, if you go over there, again, the home field advantage. Now, what do they mean by we each waive any right to a jury trial? So even if there's some sort of dispute, you don't have the right to a jury trial, so you can only have a judge adjudicate the claim. Maybe because if they really screw up, the theory is it would be cheaper and better if it's just a judge. Maybe a jury would have sympathy for a small guy, the little guy, so to speak. All right. And then just for one more example, by the way, a little trivia. After Amazon.com, what is the most popular site for sales? Online site. Let's see if the producers could hurry me from way over there. What do you guess? He's saying Nike. No, it's actually Walmart.com. Okay, so Walmart.com is the second most popular site. So I pulled up the terms and services of Walmart.com. This one is totally different than the other ones, and it says here, please read this section carefully. I know most of you have never read this and you've just agreed to the terms without ever reading, right? It may significantly affect your legal rights, right? So now the next, long story short, it says here, any sort of dispute will be resolved through final and binding arbitration before a neutral arbitrator instead of in a court by judge or jury. You agree that Walmart and you are each waiving the right to sue in court and to have a trial by jury. You agree that any arbitrator will take place on an individual basis, meaning like no class actions and not even no class arbitration. Class arbitrations and class actions are not permitted, and you are agreeing to give up the ability to participate in a class action. So, just like the other ones, they agree. You're agreeing to waive a class action, and then you're also agreeing that you will go to binding arbitration instead of a court. Now, a lot of people think that that's a big advantage to a big company because the arbitrators get paid by the case and by who hires them. So there's this financial incentive that they would rule in favor of Walmart just because Walmart will keep going to arbitration. So if I'm an arbitrator, I'd be like, "Can I hook up Walmart? Wink, wink." Right? Maybe they'll keep coming back to me. That is a big financial incentive. So theoretically, there's a financial bias, and that's why a lot of big companies prefer forcing the consumers to go to arbitration. Just for that reason. I've had so many cases where it's like they said, well, you got to go to arbitration. And it's almost like the defendant, the big corporation's like, therefore we're going to win, right? There's been a lot of adjudication about that. And a lot of these reputable arbitration firms like JAMS and American Arbitration Association, they say that no, our arbitrators are very neutral. They're not biased. They go through these training programs, blah, 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 right? Okay, whatever that's worth, that's how it goes. Okay, now, so long explanation about that dispute resolution, okay? And the dispute resolution clause in the contract with Odell Beckham and Nike said that if there's a lawsuit, he has to sue Nike in Oregon, okay, in Portland, right? And that's why his lawsuit against Nike is in Portland, right? Okay, so he, just a little bit of color background here on the, Odell Beckham Jr., he played football at the Louisiana State University, right? The Tigers, and he graduated there in 2013. He was a first-round pick by the Giants in the 2014 draft. Okay, he was the 12th pick, so it was picked very high, wide receiver, and right out of the gate, he signed a contract with Nike. What we could say is a small contract. All right, the first contract he signed with them, it was small in dollar amount, and it led to this multi-million-dollar lawsuit later. Okay. So he signs that contract in 2014, and there was a guarantee, only 3-year guarantee, and he'd be making $45,000 a year, plus a small percentage on sales of, Odell Beckham shoes or Odell Beckham gloves, things like that, right? So he's going to get a guarantee of $45,000, and then this year, and then after that, there was these two provisions that are very important, this jurisdiction provision, and then there was another provision in that 2014 contract that only lasted for 3 years that was very important, and that provision was called the right of first refusal. I hate those provisions, and what those provisions mean is if Odell Beckham, if you, after this contract, if you ever want to contract with another footwear designing company, right? Then Nike has the right of first refusal, meaning before you can sign with another company, you have to give us that same right. So whatever the best offer you get from another reputable company, you have to let us match it. That's the right of first refusal. A lot of times it's also, if there's a big lease agreement, let's say, whatever, some sort of like a restaurant is leasing some sort of property from the landlord, it'll say in there, if the landlord ever sells this property, this tenant will have the right of first refusal, meaning at whatever price that, they can sell it for or get an offer at, we have the right to match it. And if we match it, then we get to get it. So that was in that small 2014 contract. Now, what happened after that was he became a big shot, right? With catches like that, and he's playing here, and people just love him, right? This is OBJ. No, wait, yeah, I don't like the OBJ. What's it called? I use ODB, Odell, ODB, Beckham. Anyway, but obviously he likes the logo OBJ, not ODB. Okay, I get that confused with LBJ, the late president. Okay, so nonetheless, what happened then is he became a big shot from 2014 to 2017, and when his contract was set to expire with Nike, along comes Adidas. All right. What did I say about Adidas? My friend Sean in grammar school said Adidas stands for all day I dream about sex. And until I think high school or something, I thought that's what it really stood for. But no, it's just the company name, Adidas. Okay, so in 2017, Adidas offered him a ginormous contract, like 4 or 5 million, or it went up. So let's say it's just to round it off, it starts at $4 million guaranteed, and it goes up a little each year for 5 years. So from 2017 to 2022, he'd be making a guarantee of about 4 or 5 million. It escalated little by little. And then with the increase, if the percentages sales, or were higher than a certain amount, and then the contract guaranteed that if he's hitting those numbers, and it defined it as if the net sales are at least that amount that they're paying him, then they guarantee another 2 years, so a 6th year and a 7th year. And if in the 6th year and 7th year, those numbers are still, the net sales still hit what they're paying him, then they'll guarantee like an 8th and 9th year. Okay. So those, oh, by the way, the reason why I don't like those right of first refusals is, my theory is, if Nike and Odell Beckham are getting along, like why, then they'll just contract again. Do you see what I'm saying? Like, why force him to stay with Nike? Obviously it's a big benefit for Nike and it's not a big benefit for him, right? Especially if they're not getting along. So a lot of times those right of first refusals end up in lawsuits like this, just for that reason, okay? So anyway, so Adidas gave Odell Beckham this ginormous contract offer, and pursuant to the terms of the 2014 contract, Odell Beckham had to give that offer to Nike and give Nike 10 days to match it. Sure enough, Nike said, we will match that contract. We want you to stay with Nike. So he was stuck with Nike, so to speak, right? Then in 2017, now we're getting into how this ginormous lawsuit happened. In 2017, Nike then sent Odell Beckham and his team of lawyers or whoever, this contract saying, okay, we're going to extend this, we're going to match Adidas, and we're going to have this contract for 5 years. And if he meets this, earned royalties, of that certain amount, 4 million, 5 million, whatever it is, as it escalates, then we'll guarantee after 5 years, a 6th and 7th year. And if he meets the earned royalties in those years, and we're going to guarantee an 8th and 9th year, right? Odell Beckham signs that contract, blah, blah, blah. We have a deal. Now comes to 2022, isn't it? We're in the year 2022, right? So the 5 years is up. There's something very small here that was overlooked, okay? And you probably, I even slipped it in here while I was talking to you. You notice when I was talking about the Adidas offer, I said the term net sales, right? And then when I was talking about, that's the Adidas term that they used. With the Nike contract, I used the term earned royalties. All right. And what the heck is going on here? What happened was quite frankly, the lawyers for Odell Beckham, in my opinion, they didn't catch this very important change, okay? And it happens, right? They somehow either they didn't catch it or they didn't catch it, okay? And it kicked them in the butt. Da-da-da-da. See what I did there? Okay, so they didn't catch it. And the difference being this, in the Adidas offer, they said to Odell Beckham that as long as the net sales defined as just the sales, all the sales, if the net sales are what we're paying you. So in the 5th year of the contract, for example, let's say the guaranteed amount was 4.5 million. As long as the net sales are still 4.5 million, then we will, then there's guarantee of 6th and 7th year, okay? The Nike contract said as long as your earned royalties are 4.5 million in the 5th year, then we'll guarantee a 6th and 7th year. What the fudge is the difference, right? It was his earned royalties, meaning his royalties are 5% of the sales. Okay, so for him to get earned royalties of 4.5 million, Nike would have had to have sold $90 million worth of shoes and gloves and shirts and whatever, right? 90 million, because 5% of 90 million is 4.5 million. I hope I got that math right. I think so. Yeah. Okay. All right. I might be off by, whatever, but yeah. So that's the deal. He has to have sold $90 million in the year 2022 The year may have started like it's a fiscal year, so it may have started like late last year in 2021, but I'm just going to say, the fiscal year 2022. So he would have to have sold, Nike would have had to have sold $90 million in shoes for that contract to be guaranteed for a 6th and 7th year, and then the same for an 8th and 9th year. So we're looking at 4 years at, and it escalated an average of $5 million. That's why it's a $20 million lawsuit, because 4 years times $5 million is $20 million. What ended up happening is he didn't meet that number, right? I mean, this is Odell Beckham Jr. I'm sorry to say it's not like Jerry Rice. Just kidding, right? No, not like Michael Jordan. They would have met that number, but no. He's an awesome player. Okay, so he didn't meet that number. Had he signed the Adidas contract, the only number he had to meet was that the net sales would have just had to have been $4.5 million. And as long as that's the case, then Adidas would have continued that base, like the guaranteed base income. Do you see what I'm saying? So that flippin' oversight ended the contract with Nike. And now in his current lawsuit, what his law firm is saying, or the law firm that represents him is saying, is that, well, they pulled the wool over our eyes. Where does that term come from? Right? They pulled the wool over our eyes. We didn't notice. It wasn't the intent of the parties to do that. And they agreed that they would match the terms of Adidas. And technically, those were the terms of the Adidas. So that's what we should go by, right? That is Odell Beckham's position. Nike's position is, well, our contract is different and we have other favorable terms here. We're going to, there was continuity and there was other favorable terms, and that term wasn't, necessarily favorable, but, we match the theory of the contract or the offer. And nonetheless, this is what we agreed to. And this is what he signed, dang it. And blah, blah, blah. Oh my God. All I got to say is I'm glad I wasn't involved in that signing of his contract in 2017 because, I don't know. Is that legal malpractice? Maybe not. I don't know. Maybe it is. That's pretty freaking close. So that is the gist of this $20 million lawsuit. The difference between net sales and earned royalties, okay? And that's it. I mean, that's the whole lawsuit. Okay, so here, let me explain. Let me cite how they said it. This is the actual lawsuit filed on November 14, 2022. So just a few days ago. The change from net sales to earned royalties in the trigger for the guaranteed extension for contract years 6 through 8 was never discussed between Nike and Mr. Beckham and was inconsistent with the parties' existing agreement that Nike was matching all the terms of the Adidas offer, as reflected in its letters discussions with Mr. Beckham. The next paragraph 38 of the complaint, there was no intent by Mr. Beckham to amend the agreement he had reached with Nike as reflected in the term sheet, and plaintiffs were not informed of any intent by Nike to do so. Even if Nike had intended to amend the term sheet, there was no knowledge or agreement by Mr. Beckham for such an amendment, nor any consideration. What they're saying is they didn't know, they didn't realize there was an oversight of one little term that cost $20 million in damages. Okay? Fudge, I love Odell Beckham. I think that Nike's going to win. All right. I don't think Odell. Why? Because Odell Beckham had lawyers. He had all that good jazz. And a lot of times in contracts, there is this provision. It's called an integration clause. All right. And in almost every contract, the integration clause states that our agreement is solely based on the words of this contract and the letters in this contract. Nothing we said, nothing earlier than this contract. All of that is not part of this agreement, is null and void, and all the agreement is what's in the contract. That is called the integration clause. And ordinarily, that clause also is enforceable, especially when it comes to sophisticated parties like Odell Beckham and his legal team and Nike, right? It's hard to get around that. There's been some cases where, let's say there was a typo, like let's say, in year 4, it said something like, like they forgot a decimal point. So instead of $4 million, with all the zeros, it looks like $400 million, right? What a bummer. That would be awesome for Odell Beckham. But there is case law that is, if it's an honest typo that everyone looked over, we won't enforce that. Do you see what I'm saying? Like, because that would be a bummer for Nike. Or if the obvious typo is, instead of it saying 4 million, let's say the comma had a decimal point and it looks like that's $4, $4.000000, right? So if it's an honest typo, there's all this case law that says we will not enforce the honest typo. Here, it's an honest oversight, I think, by Odell Beckham Jr.'s team. So he's going to have to convince a judge and maybe a jury that the ruling should be in his favor. Well, I hope he doesn't have to go to Oregon for that lawsuit. Does he? Oh, shucks. He has to go to Oregon for that lawsuit. Damn it! Hey, I love Odell Beckham's logo. Look at this logo. This logo is rad. Let's switch the subject, damn it. This logo is rad. Look at that O. It's like a 3-dimensional O. And check out that B. It's a 3-dimensional B. And check out that J. I love the logo. Let's hope that for his benefit, somehow that logo comes back and he makes a lot more money. F Nike, right? Okay, now I want to say this lawsuit is common, this type of oversight. Anyone watch the movie Forrest Gump? Great movie, right? Forrest Gump made like hundreds and hundreds and hundreds of millions of dollars just in the box office. And then it made millions more in, after the box office, right? Right? The only thing I got against the movie Forrest Gump is that it knocked out the movie Shawshank Redemption from the Oscars. One of my favorite movies is Shawshank Redemption, and Shawshank Redemption did not win an Oscar because it happened to be in the same year as Forrest Gump, and Forrest Gump swept the Oscars, right? Anyway, other than that, I love Forrest Gump. Now, can you believe the person that made the story, okay, is Winston Groom is his name, okay, and he made the story of Forrest Gump. Forrest Gump, the movie in the 90s, was based on a book Winston Groom wrote in the 80s, okay, and what happened in that, so when the Paramount, right, and the movie producers came to that author and said, okay, we want to turn your book into our movie, right? He said, okay. So what they agreed to is that a one-time payment of $350,000, okay, plus 3% of the net profits, okay? That's a great deal. I mean, dang, dude, he made hundreds of millions of dollars, right? So the agreement was $350,000 plus 3% of the net profits. Now, get this. Apparently, Forrest Gump lost money, all right? What? Somehow Forrest Gump, and there's this thing called creative accounting, and it in finance it's called creative accounting, and in reality it's called criminal. All right. And what happened was they just had the books done in such a way where it appeared that Forrest Gump, one of the highest grossing movies, lost money. Well, let's go back to the contract with the author. It said 3% plus net profits. What it should have said for the author, I guess, would be 3% plus gross profit. And that difference is big because the company paid itself a lot of money for marketing, and it paid its employees a lot of money, and it paid its owners a lot of money, and it paid, the actors or whatnot a lot of money. And after all of those bills, apparently, somehow, movies always lose money, right? And he wasn't able to get anything past 350 grand for that particular movie. Because of that one little difference, net profits, if it had said gross profits. Dude, this is a true story. I had one case where it was a divorce case. This was a while ago. And part of it was we were evaluating the business, right? The business that the husband was running. And I remember in the deposition, they're looking at it and be like, okay, so you're saying last year, husband, this is the deposition, you made no money last year? He said, I made no money last year. You made no money last year? I made no money last year. You made no money last year? I made no money. And I go, okay, there was $400,000. He's like, yeah, I made none of that. And then we're like looking over it, like, okay, how does that? Okay, so 120,000 was to like employees that were on payroll. Okay, so then there's 280,000 left. Okay, 30,000 was rent. There's 250,000 left, and there was like marketing. Some other expenses were 30,000. So there was 220,000 left. Let's say I might be off right now on some of the numbers, but so 220,000. And guess what? So his salary that year was 220,000. And what he said, and I quote, this is what he said. I quote, this is what he said. This is not me talking, okay? I quoted what he said. After I paid myself, I made no money. So I said, let me get this straight. After you paid yourself, you made no money. He said, that's right. And that's the law, okay? Because the wording, is that anything after anything of what the corporation makes. So the corporation made nothing because it paid him $220,000. It paid employees, blah, blah, blah. Same thing with Forrest Gump. After it paid the owner, after it paid the employees in Paramount, after it paid its marketing subsidiary company, after it paid its distribution company, after it paid all that, fudge! The corporation had no more money for our friend Winston Groom, okay? God, I hate lawyers. I'm starting to see why everyone hates lawyers. You know what? I hate lawyers, okay? But it is an important difference, and that's why I think our good friend Odell Beckham Jr. is not going to win that lawsuit, because I think a court would say, hey, you're a sophisticated party. You have your own lawyers. Thank you very much. And oversight, no oversight. That's what the contract says. We're going to give you Everyone sitting down for this? Oh, no. Hey, okay, I don't want to be a jerk, but that looks like an O for Odell Beckham. I'm sorry. We should editors cut that part out. All right. Hey, as always, I love you. Please run it by my lawyer. You could, Joe Samo at joe@samolaw.com, 619-672-1741. I love hearing from you folks, and I'll see you next week.